Dr Megan Woods.
Thank you, Mr Speaker, and it's my pleasure to take a call on this Canterbury Property Boundaries and Related Matters Bill and to signal that Labor will be supporting this bill at first reading and to supporting it to the Select Committee so that we can hear the expert advice and the range of submissions that I'm sure will flood into that committee for this piece of legislation. As the Minister, who has just taken his chair, indicated, this is part of a suite of legislation that is currently going through this House that is about the recovery of Greater Canterbury and Greater Christchurch, about how it is that we enter this next phase. And while it's a very small piece of legislation, it is an important piece of legislation, Mr Speaker, because boundaries and how we record the property, the boundaries over a property is actually incredibly important. For many people, it's their home and their property is the greatest asset that they will ever own in their lifetime. And the boundaries, the legal definition of that plot of land is important for so many things, such as securing security from a bank over that piece of land and the ability to borrow against it. So it is important that we get this right. And what we do know, that the sequence of earthquakes that we experienced in Canterbury over the last 5 years has actually resulted in some quite significant shifts in our land, and that we do have to now consider how it is that we are going to deal with this situation. The preferred option and the considerations that the Minister gave, the Minister Upston gave, was that we actually say that the boundary moved with the land. And what we're talking here is about land movements over 20 centimetres. And Mr Speaker, there actually were 11,000 properties across Greater Christchurch that fall into this category. So if we stop and consider the magnitude of that and the amount that the earth moved for everybody in Christchurch, Mr Speaker, that we've seen, we've had quite a 5 years on our hands. The concentration of these properties are not surprising in the parts of the city where we had the greatest earthquake damage. So the concentration is in the eastern suburbs, particularly around the New Brighton area, with pockets in the Port Hills area and in Sumner. And I'm sure that will be of consideration to my colleagues, the Honourable Ruth Dyson and Putu Williams, when they talk to their local constituents about how it is that we look at that. Because when we actually consider the magnitude of this problem, those 11,000 properties I'm describing, that's actually excluding some of the worst hit parts of the city, because it's excluding the Crown-owned land in the residential red zone. So that this actually is a significant problem that we do have to come to address, and we look forward to this legislation coming through the House. There are some significant questions, because this is so important, the basis of so many people's security, their land, and where their land stops and their neighbours starts is incredibly important if we're going to avoid a number of disputes, and that we can see that a range of methodologies have been used over the last 5 years that surveyors have used. And because of this, the bill offers indemnity to the surveying profession under Clause 10 of the legislation. And this is something that we want to examine closely at Select Committee. You can absolutely understand the rationale of why it's been put in the legislation, but we have to stop and we need to ask some significant questions around this in terms of where liability will lie. If we're giving indemnity to the surveyors who carried out this work in good faith in accordance with their profession, but nonetheless there is an error, where will the liability for those errors lie? And that is something that I think that the Local Government and Environment Select Committee will need to think about, will need to listen to expert advice on, and will need to give due consideration to. Because we know already that there's 300 properties in the Greater Christchurch area that the Surveyor General himself has identified just through a desktop exercise as being surveyed on a basis different than the preferred approach, is the language that the documents are using it. So we already know that there's 300 properties out there that already have to go and have some fix-up work done to it. So we will be looking at that. We will be looking at the issues around liability, who is liable for what, because we know that there has always been a fund that does actually pay fix-up for the Crown on these issues. The Minister in his speech asked that the Local Government and Environment Select Committee give this piece of legislation priority. Well, Mr Speaker, the Local Government and Environment Select Committee is a very, very effective and efficient Select Committee that will give every piece of legislation priority. But, Mr Speaker, one thing I do urge, and I want to put it on the record, that we will give it priority, but it needs to be seen in the context of the other bills that Select Committee is currently working through. And I'm not referring to the workload of members here. What I'm referring to is the two very significant Canterbury bills that are currently out for consultation at the moment, one of which puts in place our governance arrangements for our regional council, a very significant piece of legislation. It's our little bit of democracy back that isn't, that is something that Canterburyans want to submit on. We also have a very fundamental piece of legislation that got heard in this House and has now been opened for submission, and that's the Greater Regeneration Christchurch Bill, that itself is out for submissions at the moment, and that puts in place the transitional arrangements for how it is we are going to regenerate our city and our province over the next 5 years. Not work that can be rushed, but nonetheless, as the government has put both these pieces of legislation through with what I think are less than preferable consultation periods, that we have moved amendments to both pieces of legislation, asking that we be able to give proper and due consideration to such important and fundamental legislation as it goes through. So the last thing that I want to see, Mr Speaker, is any attempt to rush this legislation through, because it needs to be seen, just as the Minister described it in his speech, as part of a suite of policies and not something that we can just dump the Canterbury package of legislation on the people of Greater Christchurch and Canterbury and say, submit, think about all these things. They need to be able to think about these things with due consideration. I notice in the regulatory impact statement that has come out with the bill that some consideration has been given to the consultation that this bill has gone through. So a sector group was formed, including representation from LINZ itself, the survey profession, insurers including EQC, lawyers, Christchurch City Council, DPMC and SERA, and that was convened in March of this year. And I think, as my colleague, the Honourable Ruth Dyson, has identified, we have to ensure that we are giving property owners and residents the chance to be heard on this. There can be no greater stakeholder in this legislation than property owners and residents, and we have to ensure, as a parliament and as legislators, that we are properly engaging with this group and hearing any concerns that they might have. I want to hear what they think about the fact that surveyors have been indemnified. It might not be a problem, but I want the chance to have a conversation under that group. I see in paragraph 96 of the regulatory impact statement where we have the feedback from Concern and Sarah's public engagement team indicates that residents are primarily concerned that their property rights and physical property boundaries are maintained. Well, if we take Sarah as the body, this is a government department. This is not the way we go and talk to residents. And if you actually look at any kind of satisfaction ratings around that particular government department, you'll see that it's not really the way to gauge what Canterburyans and people in Christchurch are thinking. In fact, there could probably be no more ineffective way to engage with the people of Christchurch and Canterbury than through the auspices of Sarah. But this is the doozy, and this shows that how much time the Select Committee does have to spend on this. Direct engagement with property owners on the proposals will occur through the In the Know Hub. Well, the In the Know Hub is a hub set up for people to go and seek advice around EQC and insurance issues. I suggest to any member on the government benches, if you want to start having another conversation with someone that's been locked in a battle with EQC and their insurance company for the last 5 years and start indicating that their boundaries might have to change as well, good luck to you. This is not an effective form of communication. We know how fraught this is. Only last week, this facility actually had to be closed down because a resident threatened to go down with a gun. This is not a place to start having other conversations. This is a place where very stressed and very fraught individuals are going to seek advice. To even suggest that this is a way in which we should be consulting on this legislation is just laughable. And it is why the Select Committee has to be given good time to have proper consideration of this. Labor will be supporting this bill in first reading. We think it's important that we get this sequence of legislation right, Mr Speaker.